Please keep the following in mind as far as your questions in the chat. Questions about your individual case or your situation cannot be answered, so please do not ask them. We cannot speculate on exactly how SCOPA will rule. PARSOL provides legal information, but not legal advice. Check with your attorney with follow-up questions around your specific situation. So at this point, I'd like to introduce Josiah. He's the chair of our legal committee, and he's going to provide a history of where we're at with the Torsilieri case.
So thank you, Randall. Good evening and welcome. You're all probably familiar with the name George Torsilieri, his Pennsylvania Supreme Court case, and the opinion handed down by the Honorable Allison Bell Royer of Chester County. But it's important that we take a few minutes as a refresher before our legal analyst dives deeper into how the cases of Elaine versus United States and Apprendi versus New Jersey play a significant role in the case of Commonwealth versus George Torsilieri. The first Chester County opinion was issued by the Honorable Anthony Sarcione in August of 2018. The Commonwealth filed a direct appeal to SCOPA, and the case was heard and decided on in 2019 and 2020, respectively. The primary argument heard before the court was whether SORNA's unchallengeable claim that all sex offenders pose a high risk of sexually reoffending violated the Pennsylvania's Constitution right to reputation. SCOPA found that they did not have enough information to come to a final decision. Therefore, they remanded or kicked back the case to the Chester County Court of Common Pleas for an evidentiary hearing. Judge Sarcione had retired by this time, so the case was assigned to Judge Allison Bell Royer. The case was heard in June of 2021. Her opinion and court order was issued a year later on August 22nd, 2022. Again, the Commonwealth filed a direct appeal to SCOPA. This now brings us to round 2 of the oral arguments coming up in 10 days. So what exactly happened with the latest Chester County ruling? The 2022 Chester County decision found that SORNA is unconstitutionally both facially and as applied to Mr. Torsilieri on the basis that it employs an irrebuttable presumption that is not universally true. An irrebuttable presumption is a legal doctrine that establishes a certain fact or inference as conclusive and prohibits the introduction of evidence to the contrary. It is a presumption that cannot be overcome by any evidence, no matter how strong or compelling. A 3-pronged test was utilized to determine whether an irrebuttable presumption is constitutional. So let's look at these 3 criteria and what the court found as a result. The first part of the prong is whether the irrebuttable presumption encroaches on an interest protected by the Due Process Clause. The court found that Article 1, Section 1 of the Pennsylvania Constitution provides a right to reputation which supersedes any rule set forth elsewhere. Second part of the test is whether the presumption is not universally true. Here, the court heard significant evidence from nationally recognized experts. They reported that 80 to 95% of PFRs, that's persons forced to register, do not sexually reoffend. And the third part of the test is whether a reasonable alternative means exists for ascertaining the presumed fact. The court heard that an internationally accepted risk assessment tool called the Static 99 and Static 99R, created by Dr. Carl Hansen, can accurately predict who is at a high risk level of sexually reoffending. So now, next, the court had set forth to determine whether SORNA is punitive. The court examined 5 of the 7 factors set forth in the Kennedy versus Mendoza-Martinez test, which is a test that was created by the United States Supreme Court, used to determine whether a government action is a criminal punishment or a civil regulation. So let's look at 5 factors and what the court found. The first factor is whether the requirements involve an affirmative disability or restraint. The court found that the Act 29 amendment to SORNA does not meaningfully reduce the palpable burden to register in person to any offender under subchapter H. Second, whether they have been historically regarded as punishment. Well, in the Lacombe case, SCOPA held that the registration and notification provisions of SORNA have historically been regarded as punishment. The lower court was bound by this determination. Third, whether their operation will promote the traditional aims of punishment, retribution, and deterrence. Subchapter H does have a deterrent effect because the registration and notification provisions are not incurred until a crime has been committed. The fourth factor is whether an alternative purpose to which they may be rationally connected is assignable for them. Well, research brought forth by the defense indicated that the relationship between SORNA's registration and notification requirements and the public protection aspect of SORNA are not rationally related, as SORNA's provisions hinder rehabilitation by impairing housing, employment, and pro-social relationship prospects, and much more, all of which jeopardizes the public safety and welfare purpose espoused by the legislature. And finally, fifth, whether the requirements appear excessive in relation to the alternative purpose assigned. The court found that SORNA's provisions are based on the title of the offense, not the personal characteristics and circumstances of the person. So all 5 factors weighed in favor of SORNA being punitive. We now welcome our legal analyst of the legal committee, Stu, to help us better understand the case, the decision from last year, and what the future of Pennsylvania Registry might bring. So Stu, welcome.
Thanks, and it's a pleasure to be here, and hope we can establish some grounds here with Elaine and Apprendi.
Yep. Okay, so let's get right into it. Stu, what crime did Torsilieri commit that placed him on the registry, and how did he challenge his registry status?
Well, he was charged with a number of offenses, but there was only 3 left by the time he went down to different negotiations and things. And the major one was aggravated indecent assault without consent, which placed him on the registry for life, I believe. And he argued in the courts that, this violates his right to reputation, amongst other things. And after a long series of court arguments and information brought by the District Attorneys Association and the Pennsylvania State Police, in the local court of common pleas ruled in his favor that subchapter H, particularly of SORNA, is unconstitutional in all the factors that we just talked about and more. So when they went before the Supreme Court, they brought the same argument, and I believe it was Justice Doherty. I'm not 100%, I can't remember for sure, but I think it was him that said, don't bring us the same thing over and over. And they send it back down to the local court, to the common pleas court, to have an evidentiary hearing on all of these issues, of which at the time the judge that wrote the initial opinion retired, and this new judge came on, and she really went to bat for Torsilieri in her opinion, and she went all out on just about every aspect that you can possibly come out with on right to reputation, cruel and unusual punishment, the Elaine and Apprendi decisions from the Supreme Court, which we'll get into later, and separation of powers and cruel and unusual punishment. And she basically came to the conclusion on all the evidence that was presented to her from Mr. Torsilieri and his lawyers that SORNA in Pennsylvania is indeed unconstitutional in regards to the Pennsylvania Constitution.
So, Stu, thanks for that. I'm wondering, was this like an appeal of his conviction that got him all the way to the Supreme Court, or did he start like a new case to challenge being on the registry?
No, it was part of his conviction. I guess in his, I'm just speculating on this, on his personal talks with his lawyers, he said, why do I have to do all this time on Megan's Law or SORNA? Because my sentence was this, but now I have to do this forever. You know, to me, that sounds like double jeopardy. It sounds like two sentences for one crime. So they brought this forward because in Commonwealth versus Muniz a few years ago, this same Supreme Court ruled that subchapter H is in fact punitive and therefore a punishment. So I guess basically the way it came out is his lawyers were saying that he was punished by this amount of time of jail and probation, and now all of a sudden he has to do this punishment called SORNA for the rest of his life. That's two separate things, and they actually have two separate hearings for that. So
Okay, yeah, that makes sense. He didn't have to start a new case because this was part of his punishment
yeah,
for his
right,
conviction.
his case was
Now,
active, yes.
you mentioned in your response, you know, the long process, and not everyone here is familiar with the court system here in Pennsylvania. Can you outline the levels of our courts from, you know, the lower court where it starts all the way up to the Supreme Court?
Okay, well, the first thing that happens, as most people know, is there's a criminal complaint filed by someone. And once that complaint is filed, the local police or the state police investigate, and they do an investigation. And if they feel that they have probable cause that a crime was committed, they go to the local magistrate court, which I think may be different in Philadelphia County, but for the rest of the state, it's called the Magisterial District Court. And they go there and they present their affidavit of probable cause to the magistrate, and he or she issues an arrest warrant. And once that happens, the police can arrest the person, and the process begins with what's called preliminary arraignment. And this happens at the magistrate level. At the preliminary arraignment, the charges are read to the defendant so he knows what's happening to him. And then bail is set, which can be anywhere from 0 to whatever amount the judge feels is necessary to make sure that person will show up in court. And if you make bail, you get to stay at home with maybe some provisions. If not, you would go to prison until your hearings. The first hearing then would be your preliminary hearing, which is at the magistrate level. And at that level, they have to prove what is called prima facie, which means that the district attorney and the police and maybe possibly the victim have to testify and say whether or not what was brought in the affidavit of probable cause is what they're saying. And if that's true, if it is, then it's called prima facie, has been established, and the magistrate will pass it on to the Court of Common Pleas, which we call our county court, like Dauphin County or Lancaster County or whatever county it may be. And once you get to that level, that's called the Court of Common Pleas. And your first thing that happens there is what's called formal arraignment. At that point, the defendant will plead guilty or not guilty. It's usually not guilty. And then the whole process begins for your lawyer to file pre-trial motions, bail reductions, evidentiary hearings, suppression of evidence, all kinds of hearings can be filed at that point before there's a trial. And then at some point along those lines will come the district attorney, and he may offer a plea negotiation. So say for example, your crime can consist of 7 years in jail, 3.5 to 7 years in jail. He can come along and say, well, you know, if you plead guilty to this, we'll give you 2 to 4 years instead of the 7, and things like that. And your lawyer and you the defendant negotiate back and forth with the district attorney if that's something agreeable. And if so, it's brought before the court. If the court accepts it, that's what you get. If not, you go to trial and you pick a jury, and the trial is commenced, and then the jury decides whether or not you're guilty or not guilty of the crimes that you were originally charged with. They can find you guilty of everything, nothing, or some, and not all. At that point, if you are found guilty of something, it's held for sentencing. And normally what happens then is a pre-sentence investigation occurs, which is a whole plethora of things that they go through, not just a criminal past, but psychological analysis, your job record, your family life, a whole number of other things that can be brought in that the judge can use for his discretion when sentencing you. At that point, when that's all done, your sentencing occurs, and the judge sentences you to the sentence that he feels is appropriate for the crime within the statutory limits. At that point, you're considered guilty and sentenced, and off you go to do your sentence. You have some time after that to file an appeal. The appeal is not based on your innocence. The appeal is based on whether the law was applied appropriately to you in each case. And I can't even go into all the different things they can do at that level. There's thousands. And so they would file an appeal to the Superior Court of Pennsylvania based on whatever issue that your lawyer feels wasn't done right at the Court of Common Pleas level. And then the court will hear that at the Superior Court level. You have a right to that, and they cannot deny you that. Once it gets to the Superior Court level, the Superior Court will make a decision either for you or for the other side, whether or not your rights were violated. If you still feel your rights were violated constitutionally, you can then apply to the Pennsylvania Supreme Court to have your case heard. You do not have a right to go to the Supreme Court, but you can certainly ask them to hear your case. At that point, the Supreme Court will ask you to file what's called aliquotter, and your lawyer will present the constitutional violation that happened during your process, and then the Supreme Court of Pennsylvania will decide whether or not you have merit to bring that argument. If you do have merit to bring that argument, you will then go before the Supreme Court in brief form, where your lawyer will write a brief, which is basically a long history of the case and the case law that supports your constitutional violation that you're trying to bring forth. And if the court has more issues to deal with that, questions to, that may not be clear to them, they can call upon you for a in-person visit, to come before them, for oral argument. And at that point, you have usually 15 minutes or so to present your argument. Now, on the other hand, the district attorney can do the same thing. Let's say you win in the Superior Court and they don't like the decision based on a constitutional issue, like they feel that the Superior Court ruled against the Constitution for whatever reason. They can also bring a case before the Supreme Court. And it's the same story there. They have to ask the Supreme Court, and then the Supreme Court again will have to decide whether or not to hear that. So, and that's basically all the levels in Pennsylvania. Should you lose in the Supreme Court of Pennsylvania, you can file for the United States Supreme Court at that point on a constitutional issue, but it's usually moot by then. It's very rare that it goes beyond the Pennsylvania Supreme Court.
Thanks, Stu. So obviously not everyone makes it to the level of the Supreme Court of Pennsylvania. What is it about the nature of Torsileri's case that made it more likely that it was heard by the Supreme Court?
Okay, the Torsilieri case has the constitutional violation that they were arguing, his lawyers were arguing, was basically his right to reputation, which is in Article 1, Section 1 of the Pennsylvania Constitution, where it says, and I'm paraphrasing here, where it says we have an indefeasible right to a number of things, one of which is reputation. And apparently the Pennsylvania State Police and the district attorneys do not agree with us on that. So it ended up before the Supreme Court to make a decision as to whether or not, in fact, our constitutional rights are being violated by being on a sexual offender website. In other words, ruining your reputation by having your picture, address, and occupation, your car, and your tattoos and everything listed on there. So that's where it's standing right now. And as I said before, the reason we're back before them a second time is because the Supreme Court needed clarification on some issues regarding the psychological parts of it, and recidivism part of it, things like that.
Okay, great. So it was the elements of his Pennsylvania constitutional right to reputation that was kind of his ticket to get into the Supreme Court. So,
Correct.
Josiah, I know you've been following this for a long time. This is not the first time that the Supreme Court has looked at this. How many times has our Supreme Court ruled parts of this registry unconstitutional?
Several times. There were a number.
I would say 3.5 times. Okay, and let me explain why.
Go ahead, Josiah.
Let me explain why 3.5 times. Okay, so Megan's Law 1 was ruled unconstitutional. Then we had Megan's Law 2, which the majority of that was ruled constitutional, but a part of it was ruled unconstitutional, which I'll get into. Then you have Megan's Law 3, which was ruled unconstitutional. Then you had SORNA 1, which was ruled unconstitutional. Now we're at SORNA 2, which we are still waiting to see whether or not it's going to be ruled unconstitutional. Now, going back to Megan's Law 2, this is where that half comes in, okay? So in the case of Commonwealth versus George Robert Williams, okay, also known as the Williams 2 case, he argued whether or not SORNA's provisions were unconstitutional. And he also argued whether or not the failure to register was punitive and unconstitutional, and whether it was severable. So the justice who wrote the opinion, believe it or not, was Justice, I have it up here, Justice Saylor, which he later became Chief Justice Saylor, and now he has since retired. But on page 41 in the opinion, which I have up here, well, actually starting at the very end of page 40 up to the top of page 41, it reads, because registration and verification, and this is in regards to the second half of the failing to register. The failure to register at the time, let me explain, was punishable by either a lifetime of incarceration or lifetime probation. And that was also lifetime, and that was also failure to comply with group or anything of the sort, okay? And Chief Justice and Justice Saylor, well, Chief Justice, but emeritus right now, he said, because registration and quote, because registration and verification are statutorily required, the district attorney could implicate the judicial process through an enforcement proceeding in which failure to comply with the resulting order would be punishable by the court's contempt powers. Under these circumstances, it cannot reasonably be contended that the valid provisions of Megan's Law 2 are so dependent upon the penalty provisions that the General Assembly would not have enacted the former without the latter. Hence, the penalty clauses are severable, end quote. So what is he saying? He is saying that the lifetime punishment for failure to register is punitive because it's a felony, number one, and two, it's lifetime either on probation, which is a punitive sanction, or a lifetime of incarceration, another punitive sanction. So what happened is that the General Assembly then rewrote the penalty and came up with Megan's Law 3, where the penalty came out to be much less, to like 2 to 5 years, something like that, I don't know. But it was still a felony, and it still remains a felony, if I remember correctly. And I think it's still a penalty of 2 to 5 years, somewhere around there. But what is very interesting here is that Chief Justice Saylor says that the resulting order could be punishable or would be punishable by the court's contempt powers, which is the lowest you can get, because being in contempt of court is a summary offense, and you could either be fined or even maybe do just a few weeks of incarceration. Nothing long. We could do that standing on our heads. So even the argument of, well, this was for Megan's Law 2, where it was lifetime of probation or lifetime of incarceration. Okay, but Justice Saylor gave us the fix here. He said he went as low as a contempt of court, again, which is a summary. So, and he said that it can be severable from the registration, and then the rest of the registration would stand. You just had to make this little fix. So, going to the conclusion of his opinion, quoting, "In the absence of competent and credible evidence undermining the relevant legislative findings, Megan's Law registration, notification, and counseling provisions constitute non-punitive regulatory measures supporting a legitimate government purpose. Therefore, these measures are presently upheld against appellee's claim that they result in additional criminal punishment. The prescribed penalties for failure to register and verify one's residence as required are unconstitutionally punitive, but severable." End quote. So there you go, 3.5. Hopefully we'll make it 4.
Why has this taken so long? You know, Torsilieri had his day in court years ago.
Right. Okay, so he made his initial challenge, but what happens is that you have schedules that have to be matched. Okay, you have the schedule of the judge, the court, you have the schedule of the public defender, of the defense, the schedule of the prosecution, and they all have to come to an agreement of set dates of when we're going to have this arguments or when we're going to have hearings. But then also you have briefs that need to be written, and that's usually later on in the higher appellate courts, where you have briefs that need to be written, and you are given generally 30 days to write your brief, but then you can also file for an extension twice, I believe, and each extension is another 30 days on top. So it could take 90 days to write one brief. So you have the brief for the appellate court, brief for the appellee, brief for the appellant, and then you have a reply brief. And again,
you also have, excuse me for interrupting, but you also have their amicus briefs that can be filed from various other places, and they're on the same time restraints, but sometimes when they're thrown in there, it just adds extra for the Prothonotari's office to add all those people in. So sometimes there could be delay there too. Right. Which happened in Torsilieri.
Right. And then they had the argument, but the part that really takes, I think, the longest is the time it takes for the court to write their opinion, because they are not bound by time as to when that opinion has to come out. We saw that with the Honorable Allison Bell Royer, where it was in 2021. June or July, whichever I said at the beginning, I can't remember now off the top of my head, I'm sorry, where they had the oral argument for the evidentiary hearing. And then in August, a year later, she comes out with the opinion. So it can take a year for her or for any court to come out with an opinion. As for the Superior Court, SCOPA, they can take however long they want. So yeah, we're just on pins and needles right now. So Stu, I have a question for you. One of our actually not me. One of our participants asks an important question here. Does the County Common Pleas Court judgment have a statewide effect?
That's a technical question with a technical answer. Yes and no. Okay. First, we're going to say no. Usually a county court, when we're dealing with a constitutional matter, obviously can and does rule on constitutional issues, such as Torsilieri's case. However, as soon as that decision is appealed by the Commonwealth, which that would be the people who would appeal it, because Torsilieri won, why would he appeal it, right?
Mhm.
So the Commonwealth has a right to appeal because it's a constitutional issue. She said it's unconstitutional, the whole law, the whole kit and caboodle. So the Commonwealth has a right to appeal to the Supreme Court, and in fact, a duty at this point, because of the nature of the hugeness of this statute, to ask the Supreme Court to hear the case. And because the Supreme Court is the arbiter of the Constitution in Pennsylvania, they're going to more than likely take the case, which of course they did. But let's speak hypothetically here and say either A, the district attorney never appeals, or B, the Supreme Court refuses to hear it for whatever strange reason. Then yes, her ruling would be unconstitutional throughout the entire state, because that's what she ordered. But it doesn't even make sense to do something like that, to have one judge in one county make a decision for the whole entire state. It has happened in the past. One of the bigger ones was in Allegheny County, when they tried to issue where sex offenders can live a couple of years ago. And that eventually also made it to the Supreme Court, but that one took a while to get there. And when the Allegheny County Court of Common Pleas ruled that in favor of the defendant, a lot of other counties that had the exact same ordinances and laws on the table immediately tabled them and put them aside, because the county court issued such a good decision, you know. So yeah, it has different effects depending on what it is, but technically speaking, yes, they can, but more than likely, which is 99.9% of the time, because there might be one out there somewhere that didn't happen. Yeah, the Supreme Court's the court that rules things unconstitutional. So I wouldn't count on my county being the place to find something unconstitutional in the whole state. If you bring something of that nature and it happens for you, great. But chances are you're going to be standing in front of the Supreme Court.
All right. So we have the court order here before us, which we were lucky enough to get. And this court order was from August 22nd, 2022. And she makes a whole list of judgments on here. So let's go through this order line by line and analyze this real quickly here. So SORNA is unconstitutional both facially and as applied to this defendant on the basis that it employs an irrebuttable presumption that is not universally applicable. What is as applied challenge versus a facial challenge?
A facial challenge is your more common thing, and that's like John Smith coming to court for whatever issue, and you know there's a glitch in his case or whatever, and the court says, okay, something wasn't done quite right here. The rules of the Constitution weren't followed correctly in light to this guy. So for him, this is as applied unconstitutional, because his rights, his particular human one person rights were violated. So that's what as applied means. As applied means to the defendant, which in this case, George Torsilieri, was all good for him. And I congratulate him on that. However, facially is a whole different ballgame. When something is declared unconstitutional facially, it means that the statute itself, not based on anything the defendant argued individually for his individual rights, but for the rights of all Pennsylvanians regarding a constitutional issue, such as the right to reputation, and how it affects everyone that's on the registry, not just George. So this judge from Chester County, after hearing all the evidence and weighing all the arguments, came to the decision that this case is facially unconstitutional. That means the statute on its face, as it stands, is not a statute that can weigh in on the rights that we have under the Constitution. So therefore, it got to go. That's what facially means.
All right.
Now, if you look back at the Muniz case, there was a lot of hope that Megan's Law would be brought down. But if you look closely at that case, it was as applied. But the reason for the stir was because as applied to Mr. Muniz could also be as applied to everyone else, and people will be filing all kinds of PCRAs as a new constitutional issue. So that's why the legislature scrambled to put a Band-Aid on what they had. But in this case, we're sitting here with the word facially, which means from the very first section of this statute to the very last word of it is unconstitutional.
Interesting. So now we come to the primary focus.
According to Judge Royer.
Right.
Not according to anyone else at this point.
Right. Okay, so now we come to the primary focus of tonight's presentation, of tonight's discussion of Apprendi and Elaine. And this is one that goes over a lot of people's heads, I think. Its punitive nature offends Elaine and Apprendi. So who are Apprendi and Elaine, and what did their cases argue?
Okay, I'm going to talk about Apprendi first, and I'm going to talk much less about Elaine, because what happened in Apprendi is the decision that was made in Apprendi is just applied to Elaine in a different way, which I'll get to when I get to that. But I want to start off with Apprendi because it's the older case, and it's the one that actually brought all this forth. And this Judge Royer in Chester County was very astute as to applying these United States Supreme Court cases, which is a U.S. right, not a Pennsylvania right. It's in the U.S. Constitution because it comes from the United States Supreme Court. So what happened in Apprendi, this was way back in the early 2000s, if not 1999 maybe, but it was way back then. And basically what happened, this guy shot a whole bunch of people. And after he was brought in, he said some racial things about the one person that he shot. And so the district attorney in New Jersey charged him with all these crimes, and then of which he pled guilty to some of them. And then after he pled guilty, they tried to apply what we would call in Pennsylvania an ethnic intimidation statute enhancement. So what happened there was after he pled guilty to his, attempted murder crimes and things like that, the state came in and they said, well, we want to enhance his sentence on this particular charge because he said he did it because the people were Black. He then recanted that, but that was a whole other argument. So what happened was he went to court and he was sentenced. The sentence for his case, for his crime, was a maximum of 10 years. And what ended up happening, because of the racial intimidation statute that New Jersey has, they said that by a preponderance of the evidence put in front of the judge at sentencing, we can add 10 more years to this guy's case because of this racial slur that he supposedly said. So basically, his 10-year maximum turned into his minimum because it added 10 years to the case. So a 10-year sentence became basically a 20-year sentence. And so he appealed it and then went all the way up through the courts and everything. And it landed with the United States Supreme Court based on double jeopardy and cruel and unusual punishment and things like that. And so basically what the Supreme Court ruled was that anything, and this comes from common law. You can go back, and I'm not going to read the whole Supreme Court case, but this goes back to the times of English law, where back in those days, you were found guilty of a crime and sentenced on the same day. So there wouldn't even be a time for the attorney for the state to bring up an enhancement of your sentence, because there would be no time to do that. You're just found guilty and sentenced. So according to the common law, according to the United States Supreme Court, written by Justice Stevens, he said that this enhancement that they're talking about for a racial slur is an element of the crime. It's not an element of the sentencing. So that means if it's an element of the crime, any element that's in your crime has to be brought before the jury for a decision as to whether or not you're guilty of that. And in this case, it was racial slurring. So when he pled guilty to all these other crimes, he did not plead guilty to the racial intimidation because it wasn't a factor that he could plead guilty to. It was a factor of his sentencing. So the Supreme Court said, no, that is an element of the crime because you're extending his sentence beyond the normal statutory amount of time for a sentence, which in this case was 10 years. So the Supreme Court of the United States ruled that any element of the crime, of a crime that enhances your sentence beyond the normal sentencing range for your particular crime, must be an element of the crime and presented before the fact finder, which is usually a jury. So the jury did not have an opportunity in his case to even look at that fact of his situation. And in his case, he took a guilty plea. Therefore, in fact, he never even had a chance to plead guilty to it because it wasn't a crime that you could plead guilty to. It was a factor of sentencing in New Jersey. So the Supreme Court said anything that extends your maximum sentence must be brought before a jury for them to determine whether or not that extension is worthy of you getting it. So that's Apprendi. Now, what happened with Elaine? Elaine was the exact same thing, except the opposite end. Whereas Apprendi said your maximum sentence is an element, like your extension to a higher maximum is an extension, so is your minimum. So what they came out with after Apprendi, they came out with what we called mandatory minimum sentences. I'm sure people may have heard of those. So for example, in Pennsylvania, if you assault a police officer, there's not just an assault, but there's a mandatory minimum sentence applied to that just because your victim was a police officer. So Elaine says, well, if you're going to do that, even the minimum mandatory minimum of your sentence is an extension beyond the regular sentencing anyway. Even that has to be brought before a jury because it is an element of the crime. So Pennsylvania was in the process for years of rewriting all of their mandatory minimum sentences to bifurcate a jury to be able to do this, because basically what the United States Supreme Court is saying, it's a violation of our rights, even under English law, for us to be sentenced beyond what the statutory maximum is for your sentence to begin with, just because the person was a police officer, or because it was an ethnic thing, or because it was a child, or because it was an elderly person, or whatever. Those are elements. If your victim was a child, that's an element of the crime. If your victim was an elderly person, that's an element of the crime. If your victim was a police officer, it's an element of the crime. That the jury needs to know that and determine beyond a reasonable doubt that in fact it was a police officer that was assaulted. Okay, not just a judge saying, yeah, it looks like it was a cop, so yeah, okay, we're going to give you this extra time. So that's what Elaine and Apprendi are. So when you apply them to Torsilieri, like just Judge Royer did, what she was saying basically was, for example, if Torsilieri was sentenced to 5 years probation, but lifetime Megan's Law, then his 5-year probation is because it's punitive, because Megan's Law is punitive according to Muniz, his 5 years probation is extended to a lifetime of punishment, because that's what the statute requires. And that violates Elaine and Apprendi, because there was no fact ever established as an element of the crime that extends your plea or your statutory maximum for aggravated indecent assault, which is 10 years, I believe. So how do you get a life sentence if your statutory maximum is 10 years? So that's why she was saying double jeopardy, and that's why she was also saying separation of powers, because the legislature legislated that you have to be on Megan's Law for 15 years or 25 years or life. There's no discretion by the judge. There's no way the judge or a jury could determine that that can't happen to you. As a matter of fact, it's written right into SORNA, saying that no judge can overrule that part of your time you have to do on the registry. So that overextends the legislature or General Assembly's powers and gives the court basically no power to judge, no power to have discretion, no power to do anything. And that's why this judge ruled that it's against our constitutional rights in that aspect.
Mm-hmm. So can Apprendi and Elaine be argued against a civil regulatory statute?
No.
Why?
Because it's talking about your criminal, it's talking about your rights that you have when you're being criminally accused of something.
So that's why they needed to argue Mendoza-Martinez as the foundation of arguing that, look, the General Assembly said that this is a civil regulatory statute, but in reality that this is actually punitive?
It is punitive because it was ruled that way under Muniz. Subchapter H is definitely 100% punitive because of the Muniz case. And that's why subchapter I was created, because you can't ex post facto people onto something that's punitive. So all the people that were sentenced before SORNA 1 came out, which I believe was in 2012 or 2013, somewhere in there, all the people before that had the potential of being taken off. And that's why Muniz was taken off.
Okay.
Because it was ruled punitive. And now with this judge, she's saying that, yes, it is punitive and it's an extension of your sentence beyond the normal sentencing range for, in his case, aggravated indecent assault. And he has to do this for 25 years or life or whatever. And that's beyond the normal sentencing guidelines. So where was the fact finder? Where was the jury to determine whether or not this is exactly something that, can extend your sentence under subchapter H, being that it was already ruled punitive by this same Supreme Court?
Mm-hmm. Okay, so let's go to the third part of the order here, that SORNA results in a criminal sentence in excess of the statutory maximums. How does the registry become in excess of the statutory maximums?
Well, like I just said, if that would be Apprendi. If you were charged with aggravated indecent assault, as Torsilieri was, the maximum time for a first-degree felony is 10 years in that case. So how long does he have to register? Is it longer than 10 years? Then it's a longer sentence, because subchapter H is punitive according to the Muniz case.
Mm-hmm. Okay. The fourth part of the order was that it also violates the federal and state prescriptions against cruel and unusual punishment. How is SORNA cruel and unusual? I know it's kind of an obvious question, but
it's cruel and unusual because if you're being sentenced again or having to do an additional sentence to the time of your original charge, your original sentence, the judge says, I order you 5 to 10 years. Oh, and by the way, now you're going to do lifetime on this other thing called Megan's Law.
Mm-hmm.
That's cruel and unusual in the fact that you're doing two things for one crime.
Right. And the fifth judgment that she put on here in the order is in that it breaches the separation of powers doctrine. And you mentioned this already, but can you reiterate for us how SORNA offends the separation of powers doctrine?
Okay, and when SORNA was written, if you go back to the very beginnings of the first statutes that are put into it, it says that people on the registry or people that should register or have a high risk of reoffending. You know, it goes through a whole list of reasons why this law, because of public interest and all this kind of thing. So basically what the legislature, or the General Assembly, is saying is that all these other factors are way more important than your right to reputation. They're way more important than your right to not being twice put in jeopardy of life and limb. It's way more important than all those things. So therefore, we're gonna, as a legislator, because this is what the people want, we're gonna implement this statute and you're gonna live by it. And the court's saying you can't do that because we ruled it punitive under Muniz, and you're putting people on the registry to do something longer than what their sentence is. And basically what the court is saying, and the court argues this a lot when it comes to mandatory sentence or any kind of sentence that takes discretion away from the judge. It's not just sex offenses. They try it in a lot of other areas too. When judges lose their discretion, they lose their ability to be a judge effectively. If you just have to read off a piece of paper what the General Assembly tells you to do, you're not really judging, right? So it's basically a discretion thing by the judge. I mean, where does the court get the right to have discretion over a particular case when the legislature commands them to do something? So that's where I believe where she's getting at with that part.
Thanks for all of that, Stu. And you know, for those of you who haven't seen this opinion, which is still on the screen there, if you can't read it on your screen, go to our website, pull it up for yourself, read this page. It's the very last page of the PDF. It is a powerfully written decision. It was almost unbelievable to read exactly what this judge was saying and what all of the advocates have been saying for so long. So go to our website, find that decision and print it out, put it up on your wall. That is powerfully written. So Stu, thanks again. Some people have said, well, maybe a private registry, maybe that's the way to go. Maybe that'll, you know, solve the problems that this judge is highlighting and Scope is going to look at. But what would that look like if the Supreme Court rules the same way that Judge Royer ruled?
Well, a private registry, the only difference between that and the public registry is the person that has to register still has to register beyond the time of their original sentence for their crime. So therefore, you're still in the same boat. You still have to do everything they say. They're just not putting your picture on the internet. It might remedy some of the reputation thing, but what's to say you still have a bad reputation then with the police, because you still have to go to them every couple of months or a year and say, hey, here I am, I'm still me. So even a private registry goes against most of what she wrote.
Interesting. So, Randall, with you as our legislative director, I know that the Pennsylvania legislative branch has put a Band-Aid on the registry like 2 or 3 other times when it was ruled unconstitutional. Do you have any insight as to what happened there?
You know, I meet with these people here and there, and I don't really ask a lot of whys. And I guess just to answer your question, I assume it's because we have this belief in this state and really around the nation that we need this registry. We need this sex offense registry in order to keep people safe. And it's this misconception that all of us, you know, on this call and all of us who work in this advocacy are really trying to battle, that this registry is not an effective tool. And I think that the legislature and the public is stuck in this belief that, you know, this is crucial. And if we didn't have it, you know, we're going to have a super increase of sex offenses. And so I feel like the legislature is just kind of like reflecting what the public, you know, unfortunately wants. And that's our job, is to educate people on that. Stu, any thoughts on your end? Why do they keep putting a Band-Aid on this and doing it over again?
Votes. it's an easy vote getter because Democrats and Republicans, everyone's against kids getting hurt. I mean, that's an easy way of putting it. And even we don't want to see kids getting hurt or anyone getting hurt. But at the same time, you know, we still cross streets with the risk of getting hit by a car. You know, I believe, just my own personal thing, one of the biggest factors in kids not getting hurt is to teach your kids, you know, to stay away from strangers and things like that. And I think that's way more effective than the registry.
So Stu, another great question for our participants is, what role does the federal government have in Pennsylvania's registry?
The same as they do in any other state. If you go to the Adam Walsh Act, which is a federal act, establishing a federal, so to speak, SORNA, all it is it tells the states how they should set up a Megan's Law for their state. And obviously, when you go to all the different states, they're different. And you just put up a map there. You can see the states which are in compliance and which ones aren't. Now, what's important about that is, in regard to Pennsylvania and what makes us unique, there is a clause in the Adam Walsh Act, and it's section, whoop, it just disappeared on me. I don't know why I did that. It's section 125 of the Adam Walsh Act, and it's titled Failure of Jurisdiction to Comply. So in our case, that would be failure of Pennsylvania to comply. So let's pretend that jurisdiction means Pennsylvania. Under 125A, it reads, for any fiscal year after the end of the period for implementation, a jurisdiction that fails as determined by the Attorney General to substantially implement this title shall not receive 10% of the funds that would otherwise be allocated for that fiscal year to the jurisdiction under subpart 1 of Part E of Title I of the Omnibus Crime Control and Safe Streets Act. In other words, the federal government gives the state money for criminal investigations and things like that. So you would lose 10% of it from the federal government if you don't apply the Adam Walsh Act. But under section 125B, it says, right underneath that, it says, when evaluating whether a jurisdiction, Pennsylvania, has substantially implemented this title, the Attorney General shall consider whether the jurisdiction is unable to substantially implement this title because of a demonstrated inability to implement certain provisions that would place the jurisdiction in violation of its own constitution, as determined by a ruling of the jurisdiction's highest court, which for us is the Pennsylvania Supreme Court. So if the Pennsylvania Supreme Court says, the Pennsylvania Constitution says that SORNA violates your right to reputation, or any other right, but your right to reputation, Pennsylvania is not required to follow the federal Adam Walsh Act. It's right there in the Adam Walsh Act. The federal government cannot ask any state to override their constitution. And in Pennsylvania, we're in a unique position where we have this right of reputation, which isn't directly mentioned in any other state constitution. And so that gives us a hand up in Pennsylvania on that. And the feds can't come back and do anything. If our Supreme Court rules Megan's Law to be unconstitutional on its face, as this lower court did, the federal government has no authority whatsoever to make us implement what they want. Will we lose the 10% money? The answer is no, because the next section after what I just read says that if your constitution doesn't allow it, basically, we're not going to penalize you for having a constitutional right, so you still get your money. So even if the Supreme Court rules this and the DA stands there, the Attorney General stands there and tries to say, oh, we're going to lose this 10%, it's not true. Since it's in 125 section B2, you will not lose the money if the Supreme Court rules that way.
Right. So people labeled SVPs, they did get a hearing to determine that they are a high risk, right?
Yes.
Now,
What's an SVP?
sexually violent predator. It's a label of that you were found by the Sex Offender Assessment Board, where you went before them, where they had all this criteria, and they determined that you had a abnormal personality disorder or mental abnormality that puts you at a predisposition of reoffending, supposedly. So what does this mean for those who are on the registry that are SVPs? Will they still be on it?
If the statute's ruled unconstitutional facially in its entirety, everyone will be taken off. If they find a way that they can sever it, like they did in the past with like Megan's Law 2 and 3 and all that, and get your half win or your 75% win or whatever, then perhaps the SVPs will stay on. But me personally, just looking at the statute, I don't know how they can sever them from all the other things that apply. It's just a whole lot of line slicing and sentence structures that have to change and everything. I guess they could if they sat down, but even so, even if you were determined, by the irrebuttable presumption and all that, I think a good argument would be, and this is just speculation, so don't take this home as a given, but my argument would be, even if you were determined to be an SVP, how do you lose your right to reputation when it's an indefeasible right? And I believe at that point, the word indefeasible would have to be defined. At this point, I don't think it is defined by the state, which means it's the regular definition as found in the Webster's dictionary. And the word indefeasible, before everybody goes looking it up, means you can't lose that right.
Right. Okay, so now we have a question here that is to all of us. So we'll each take turns answering this question. And this comes from an audience member. What do each of you see as the next step? So Stu, you want to start us off on that?
Next step in terms of the court, next step in terms of the General Assembly. What do you mean?
Probably the next step in terms of court.
Well, the next step is the oral arguments, which are coming up at the middle of May, near the end of May, I believe the 23rd. The Commonwealth has to show the court why the common pleas judge is wrong. And I don't know what they're going to bring, but if it's anything like the past, it's probably going to be a lot of rehash. And from the last time they were in front of the Supreme Court, it was made pretty clear by the court, especially by particular justices, don't bring us the same thing again. So if they do, it's not going to turn out good for them, in my opinion.
Randall?
But after that, after that hearing is over, then the justices will go to their chambers and they will discuss it among themselves and argue back and forth with each other as to what the outcome of this should be. And we'll never know what those discussions are. However, if it comes back a 3-3 or a 4-2 in our favor, then we win. The reason 3-3 is because we already won on the lower level, and a tie means we win. And there's only 6 justices right now because of the unfortunate death of Chief Justice Baer recently.
Right. And it is my understanding that according to the rules of appellate court procedure, that if it's a tie decision, then the ruling based on by Justice Allison Bell Royer in Chester County stands as is.
Correct. And that's one of the rare instances where a lower court can rule it unconstitutional for the entire state. We asked that earlier, remember?
Right.
So that would be an instance where the lower court, their opinion stands for the whole state.
Wow.
Thanks, Stu. A follow-up, and maybe an unfair question, but people want to know, when is the Supreme Court going to release their final verdict? After oral arguments on May 23rd, how long do we have to wait?
From May 24th to eternity. We don't know. There's no answer to that.
I think, okay, so this is just my guess of when I would put money on this, put a wager, based on some of the past, how long it takes for some of the past things to come through as for timeline wise. I would say we could probably have an opinion sometime by Labor Day, or maybe by Thanksgiving.
I agree with that, but it could possibly be earlier because they've been weighing this case for a very long time.
Oh, really? Yeah. Well, yeah.
But, it can take any amount of time. But the reality is probably within a year or less.
Mm-hmm.
All right. Well, to get back to Josiah's question, what do you see as the next steps? I live in Harrisburg. The capital is very close to me, so I've made it my next step, and steps for the last year or three to meet with the lawmakers and let them know what's coming. So, I give them basically this presentation in a very abbreviated form, and point out to our senators and our representatives who work for us. Again, we elect them, we pay their salaries, we have every right to bring our issues to them. Let them know that this has happened in 1999, this happened in 2003, this happened in 2013, this happened in 2016, where parts of this law have been ruled unconstitutional. So where are we going to go next, guys, ladies and gentlemen, in the House and in the Senate? What are we going to do next? We can't keep doing this over and over again. I talked to him about prevention. I talked to him about how the registry is ineffective, and get back to prevention. If we really want to tackle this issue, which harms a lot of people throughout, our state and around the world every day, then there's a better way to do it. There are researchers who have devoted their lives and their livelihoods and their work to talking about prevention and how you can start addressing sex offenses, sexual victimization, and grooming, and you name it, and online images, and all of that. So if you want to tackle this issue, which we all do, let's look at the experts. What are they saying? And they're saying, the arguments that were used in this case, talking about low recidivism rates, talking about who is likely to offend who, and I try to educate them there. So
we might also want to reiterate to the General Assembly, the House and the Senate members, that Judge Royer, I'm giving her a raise here, Judge Royer even mentioned in her opinion, it's a very lengthy opinion, and she even mentioned that the registry can actually cause people to offend by being homeless, by being ostracized, by feel like they're left alone, by making it hard for them to have a job, and those all come from different psychiatrists and psychologists and
that was actually in a study done in California.
Yeah, I was just going to say, from a study that was done by these people. So the question to the legislature is, if there's a possibility of somebody reoffending because they're on the registry, is the registry a good idea just because people like it? How would they answer that question?
Yeah, so there's a lot to talk about with these people, and I always invite them before we get into what I want to talk about. Have your constituents brought this up to you? Has your office been contacted about the registry, good or bad? And they all say no, this doesn't come around. And so I invite you, listener, tonight, if you're not involved and if you're interested, if you're so inclined to talk to your representative, your senator who works for you, contact us, get in touch with us, and we will provide training to you. We will provide help and assistance, and you can let your representative know what the registry means in your life, in your family member's life, and share with them some of the real effects that Stu and Josiah just mentioned about employment, despair, shame, being singled out, and never truly getting to re-enter society like people who do their time are supposed to be able to do.
And one of the things one of the things that really hasn't been addressed too much is the young offenders, people between 18 and 25, whose minds really aren't fully developed yet. Anybody who has kids knows that. And putting them on these registries where they have to deal with the peer pressure of their own peers, just going out to play basketball at a playground or something with their friends, and somebody sees that, and the ostracization that could occur because of that, that in that point of your life, that's a very important socialization is very important at that age, to feel accepted and things like that at college age, and like that. And I don't see how the registry helps those people at all. I mean, I just don't. I think that's probably the worst part, for the very, very young people that are on the registry. And if we go back to In Re JB, which involved juveniles being on the registry, I think there was some touch on that, but it could very easily apply to teenagers, guys and girls in their early 20s as well.
Yeah, I think it's tough at any age, and when you're an adolescent, it's even tougher. Just to wrap up my answer here, for the next steps for me, education on the members, the senators and representatives on what's coming, and having to admit the Supreme Court didn't rule yet, guys. So I'm telling you what, this lower court said and how strongly it was written and the likelihood that this is going to happen. But I got to admit, the Supreme Court didn't rule yet. So I
Yeah,
can't tell you anything with authority, but get ready because it's coming.
yeah. That's one thing I want everybody in this room to understand, that the Supreme Court hasn't ruled on this yet. And it's great that Judge Royer did. But this is a keep your fingers crossed thing right now, and hope that the lawyers present this well before the Supreme Court, which I believe they will, because I know some of the lawyers involved. But, it's still up to those 6 justices. We can speculate all we want, and we have the facts before us, but behind those closed doors, and they know more about the law than we do. So, but just from reading what we read from Judge Royer, it sounds good.
Right. And I know the legal committee, after the May 23rd oral arguments, the legal committee is going to come together and listen to the oral arguments together and try to decipher or get any clues of which way the court might go. This would all be speculation on our part, which we're not going to share with, at least we don't think we're going to share with the general public, but we will definitely give an analysis of what went down and what was said in the courts and what looks good for us. And then also being part, and then also not am I just the legal committee chair, but I'm also the chair of the Education and Information Committee. So we're definitely going to be putting all this together into different formats, whether it's YouTube videos, audio podcasts, I don't know, articles, emails, whatever. We're going to try and get all this information out to you in as timely of a manner as possible. And it's going to be a lot of work, but it's going to be well worth it. But the challenge is we don't know what they're going to rule. There's numerous possibilities, numerous combinations of how they can rule. And so just trying to even create a template of an article or a press release is right now impossible until they come out with their decision.
Just for the public listening, I just want to say that when these opinions do come out, there can be more than 2. There will definitely be at least 2, unless it's unanimous. There will be a dissenting opinion that goes along with the opinion in our favor. But there can also be concurring opinions where justices come to the same conclusion just by a different way. So, all of those things will have to be analyzed. If there's United States Supreme Court issues involved in this, it could be put up to there. But if it's based on right to reputation all the way through and through, it won't go there, because there's no U.S. constitutional right to reputation like it is in our Constitution. But you can bet your bottom dollar, if we win this and the registry can be taken down, that they will at least try to go to the United States Supreme Court. But that's like jumping in the pool with no water. So, it's just, there's a whole bunch of possibilities that could happen. But I just want everybody to know that there can be more than one opinion coming out of this court, that they'll all have to be weighed together. I can say with almost 100% certainty that 2 justices will vote in our favor. But I can't not guarantee anybody that good to hire than 2 of them, but we need at least 3.
Right. And before we get into the next question, I do want to mention that if any of our participants here, any of our listeners have attorneys who are passionate about these issues and might be willing to provide some support to PARSOL, please let us know. Email us their information and we will reply to them as soon as we can. And you can reply to any of the emails that you got about this event and we'll get back to you.